Namaste everyone. Now in this video we are going to be analyzing the provisions of the recently introduced Vivad Se Vishwas Scheme. So let's begin. First of all, what is Vivad Se Vishwas Scheme? Vivad Se Vishwas. When this bill was first introduced in the Lok Sabha by our Honorable Union Finance Minister Mrs. Nirmala Sitharaman, she mentioned that Vivad Se Vishwas meant no dispute but trust. So Vivad Se Vishwas is the name given by Government of India to a new dispute resolution and amnesty scheme with respect to direct taxes, that is, for settlement of legacy disputes under the Income Tax Act. This scheme, after having been introduced in the 2020 budget session, has now been passed by both houses of the Parliament, and after having received the assent of Honorable President of India, has been enacted as an act on 17th of March 2020. Subsequently, the direct tax Vivad Se Vishwas rules have also been notified on 18th of March 2020. Why has this scheme been introduced now? Earlier, in 2019, the Government of India had introduced a similar scheme with respect to indirect tax laws. That is, this scheme was known as Sabka Vishwas Scheme. Following the success of that scheme, the government decided to extend this dispute resolution mechanism to direct taxes also. Subsequently, this Vivad Se Vishwas scheme has now been introduced in 2020. This was explained by our Union Finance Minister herself in Lok Sabha while she introduced the bill. Let's listen in.
In the last budget, Sabka Vishwas scheme was brought in to reduce litigation in indirect taxes. It resulted in settling over 1,89,000 cases. Currently, there are 4,83,000 direct tax cases. 4,83,000 direct tax cases pending in various appellate forums, Commissioner of Appeals, Income Tax Appellate Tribunal, High Court, Supreme Court, and so on. This year, I propose to bring a scheme similar to the indirect tax Sabka Vishwas scheme for reducing the litigation even in the direct taxes.
So till now we saw what this scheme is about. Now who can opt for this scheme? So any taxpayer under the Income Tax Act can opt for this scheme in the following cases. Number one, where any appeal or writ petition or special leave petition for any tax dispute of that taxpayer are pending as on 31st of January 2020 before any appellate forums, that is the Commissioner of Income Tax Appeals or Income Tax Appellate Tribunal or any court, high courts, any of the high courts or Supreme Court. Such taxpayer can opt for the scheme in respect of that tax dispute. Second, where any orders were passed on or before 31st of January 2020 and the time for filing an appeal against this order, appeal or special leave petition against this order has not expired as on 31st of January, then such cases the taxpayer can opt for the scheme. Third, any case pending before the dispute resolution panel where DRP has not issued any direction as on 31st of January 2020, that is until 31st January no instruction had been issued by DRP. In these cases the taxpayer can opt for this Vivad Se Vishwas scheme. Or in cases where the DRP has issued a direction but the assessing officer has not passed an order in respect of that case as on 31st of January 2020, those cases also the taxpayer can opt for the scheme. Next, applications for revision which have been filed before the Commissioner of Income Tax under section 264. In such cases also, if the revision application is pending as on 31st of January, the taxpayer can go for the scheme for settlement of that dispute. Lastly, even in such cases where the disputed tax amount which has been found as in pursuance of the search does not exceed rupees 5 crores, in those cases as well, the taxpayer can make a declaration and then go in for this Vivad Se Vishwas scheme for dispute settlement. Two other points we want to keep in mind is that this scheme can also be opted even if the cases are in arbitration in India or abroad. Also, if any portion of the disputed tax amount had already been paid by the taxpayer as a part of deposit, under dispute, etc., even in such cases, they can still opt for this Vivad Se Vishwas Scheme for settlement of that tax dispute. So this is on who all are eligible. Previously, we saw which cases are eligible to opt for dispute resolution under this Act. Now we will be seeing which cases are ineligible for opting for dispute resolution under this Act. Section 9 of Direct Tax Vivad Se Vishwas Act 2020 explicitly lists out certain cases which are not eligible for opting for dispute resolution under this scheme or under this Act. They are: number 1, any tax dispute or tax demand, tax arrear relating to any assessment which was made in pursuance of a search which was conducted under section 132 or 132A, in which the tax dispute or tax arrear exceeds rupees 5 crores. Such cases are not eligible for this scheme. Earlier we saw in eligible cases where tax disputes in pursuance of search conducted where the demand does not exceed 5 crores. So the other side is here, where the demand exceeds 5 crores is not eligible for opting for this scheme. That is explicitly mentioned under this section. Second, those tax arrears in respect of which a prosecution has already been initiated by the authority before the declaration could be filed by the taxpayer under the scheme. So those cases are not eligible where the prosecution has already been initiated. Third, those tax arrears relating to any undisclosed foreign income or undisclosed foreign assets. Such cases are not eligible for dispute resolution under this scheme. Number 4, any tax arrear relating to any assessments or reassessments which are being made on the basis of any information received from a tax treaty which have been entered with any other country by India, which have received under section 90 or 90A of the Income Tax Act, under any tax treaty, that is any foreign tax treaty which have been entered with some other country, those cases are not eligible for dispute resolution under this scheme. Fifth, if any person in respect of whom a prosecution has been initiated for any offence punishable under the Indian Penal Code or for any enforcement of any civil liability under any law for the time being enforced, either the prosecution has been initiated on or before the declaration by such person, or such person has been convicted before filing of declaration, then these cases are not eligible for opting for this scheme, Vivad Se Vishwas Scheme. Previously, we saw that any person in respect of whom a prosecution has been initiated under Indian Penal Code or any enforcement of civil liability. Following that, any person in respect of whom any prosecution for an offence has been initiated before the person has filed the declaration under this Act, or that person has been convicted of an offence punishable under any of the following laws, any of the following acts, that is, Unlawful Activities Prevention Act of 1967, Narcotic Drugs and Psychotropic Substances Act of 1985, Prevention of Corruption Act of 1988, Prevention of Money Laundering Act of 2002, and Prohibition of Benami Property Transactions Act of 1988. Under any of these acts, these are serious offences. Under any of these acts, if a person, any prosecution has been initiated against a person, or the person has been convicted, a taxpayer has been convicted before filing the declaration for dispute resolution under the scheme, that person and those cases shall not be eligible to opt for this scheme. Next, any person who has been notified under section 3 of the Special Court Trial Offences relating to Transactions in Securities Act 1992, such person, if the notification happens on or before the declaration has been filed by that person, they cannot avail the benefit of this scheme. And lastly, any person who is to be detained, that is, against whom an order of detention has been made under the provisions of Conservation of Foreign Exchange and Prevention of Smuggling Activities Act 1974, that is, for a smuggling offence, a detention order has been made against that person on or before that person files a declaration under the scheme, then such person shall not be eligible to opt for the scheme for any case unless that order for detention has been subsequently revoked, unless that order is revoked under any provisions of Income Tax Act or any other court, has been revoked by any other court of competent jurisdiction, then that person may become eligible. But as long as that detention order is in force and has not been revoked, and that person had not filed a declaration prior to that, then that person is not eligible to opt for this scheme. So up until now in this video we saw which cases are eligible and which cases are not eligible to opt for the scheme, the Vivad Se Vishwas scheme. Now we will be seeing the procedure that has to be followed, that is what has to be done to opt for Vivad Se Vishwas scheme. So the provisions governing the process to be followed are sections 3, 4 and 5 of the Direct Tax Vivad Se Vishwas Act 2020. Let's see what has to be done. The first step that has to be taken by a taxpayer who intends to opt for the scheme is that they have to file a declaration in Form 1. Form 1 is the prescribed form. It has to be filed electronically. They have to file a declaration in Form 1 with the designated authority on or before the designated date. The designated date is not to be confused with the cutoff date of 31st of March. The designated date shall be notified by the government. It is the date up to which this scheme shall be in force. Initially, when this bill was introduced in the Parliament in Lok Sabha, it was conveyed that 30th of June 2020 shall be the designated date. Whether or not that shall be the designated date or it shall be extended is to be seen. So, the designated date shall be notified by the government. Designated authority. Who is the designated authority? The Act defines a designated authority to mean an officer not below the rank of a Commissioner of Income Tax, who shall be notified by the Principal Chief Commissioner of Income Tax for the purpose of this Act. So the designated authority shall be notified by the Principal Chief Commissioner. So once the declaration has been filed, the second step is that the designated authority shall within 15 days from the date of receipt of that declaration by order determine the total amount that is payable. That is, in Section 3, they shall determine the Section 3 details the way to compute the amount payable for settlement of this dispute. So in accordance with the provisions of Section 3, the designated authority shall determine the amount payable by the taxpayer and then grant a certificate to that taxpayer, who is to be known as the declarant from now on. So once they have made the declaration, they are the declarant. The designated authority will provide a certificate to that declarant which will contain the details of the tax arrear, the total amount that they have to pay for settlement of dispute, etc. And this certificate shall be provided in Form 3. Form 3 is the prescribed form for that. And on filing this declaration, any and all pending appeals, writ petitions, etc. We saw that those who are eligible, right? For those who have pending appeals, writ petitions, they can opt for the scheme. So once they have filed the declaration, all these appeals, etc., which is pending before the appellate forum, shall be deemed to have been withdrawn from the date on which the certificate in Form 3 is provided by the designated authority. Secondly, any appeal which is pending before any court, High Court or Supreme Court, any higher appellate forums, the declarant who has filed the declaration has to withdraw these cases by taking special leave from these courts, and then after issuance of Form 3, they have to withdraw these cases, and after making the payment of the amount determined, along with the intimation of payment, they have to file cases with the designated authority. So this is also something which has to be done by the declarant. Same case, same way, similarly, if any proceeding was earlier there for arbitration or conciliation or mediation, etc., those shall be withdrawn. The declarant shall withdraw their claim in respect of those arbitration or mediation proceedings, and this proof of withdrawal shall also be intimated to the designated authority along with the proof of payment of amount payable. So when should this be done? Within 15 days of receiving the certificate, the taxpayer should pay the amount what was determined by the designated authority, should withdraw these cases or should withdraw his claim under the arbitration, and then make the intimation to designated authority along with proof of withdrawal of these cases or appeals to the designated authority. This withdrawal and proof of payment, etc., shall be made in Form 4. Form 4 is the prescribed form for that. So along with this, additionally, the taxpayer is also required to furnish an undertaking saying that he or she has waived his or her right to pursue any remedy or any redressal mechanism which is available to them under any other law for the time being in force, or any statute or any agreement, etc., on these disputes. So once they have withdrawn the cases, additionally, in addition to the proof of withdrawal, they should also provide an affidavit waiving their claim or waiving their right to seek any other form of remedy other than under this scheme. That has to be provided in form number 2, form 2. So that undertaking has to be provided in form 2. So what should be done? First, the declaration in form 1 has to be filed by the taxpayer. Then on they'll become the declarant. So within 15 days of the declarant filing the declaration, the designated authority will determine the amount payable for settlement of this dispute, and then issue a certificate in form number 3 to the declarant. So once the form number 3 has been received, the declarant should withdraw all the appeals, cases, etc., arbitration, etc., make the payment for the amount determined by the designated authority, and this proof of withdrawal and the intimation of payment they have to intimate to the designated authority in prescribed form number 4. Along with this form number 4, they should also file another form 2, which is an undertaking saying that they waive off their right for any other form of redressal or remedy against this dispute that has been waived. All these forms are electronic forms. They are available in the income tax portal in the e-login of income tax and have to be filed online only. In case of persons who are required to file their income tax returns under digital signature, they have to file these forms also under their digital signature. In respect of persons who are filing their income tax returns under electronic verification code method, they can file these forms also under electronic verification code method. Same procedure has to be followed. Now we have come to the most important part of the scheme. You can also say it is the USP of this scheme, which is the amount to be paid for opting for the scheme. So the amount that has to be paid in order for a taxpayer to opt for dispute resolution under this Vivad Se Vishwas Scheme are to be determined in accordance with the provisions of Section 3 of the Direct Tax Vivad Se Vishwas Act 2020. So what does this section say? In this section, the cases for which the amount has to be paid have been categorized into 3 buckets. The first bucket being the cases which involve disputed tax, interest, penalty, etc. It was in addition to tax, interest, penalty also. Other than cases which are such cases. So that is the category 1. Second category will be obviously cases where the disputed tax, interest, penalty are in pursuance of search conducted under section 132 or 132A. That is the search cases. And third category is the category where the disputed amount is only in respect of interest or penalty or fees. No disputed tax. The tax has already been paid and only the interest or penalty is disputed and pending. These are the 3 buckets. In addition to this, the government has also mentioned a cutoff. The cutoff being 31st of March 2020. So what do I mean by this cutoff? Does it mean that the declaration under this scheme has to be filed only before the cutoff, and after the cutoff a taxpayer cannot avail this scheme? No, it does not mean that. So what this cutoff does is that it gives an early mover advantage. So if you file the declaration on or before 31st of March 2020, you will have to pay a certain quantum of amount to avail the benefit of this scheme. If you file a declaration after 31st March, you will have to pay a slightly higher quantum of amount so that you will be at a slight disadvantage. What the government intends to do is it tries to invite these declarations as early as possible, that is before 31st of March, for settling these disputes. That's the advantage this cutoff provides. Now let's see the amounts what will have to be paid for each of these buckets. So in the first bucket, where cases involve disputed tax, interest, penalty other than the search cases, in those cases, if you file the declaration before 31st of March 2020, you can settle the case by paying 100% of the disputed tax amount. That is, disputed tax here means the income tax plus surcharge plus cess. So when you pay 100% of this disputed tax, the interest and penalty gets waived and you can settle the tax dispute. Whereas if you make the declaration after 31st of March, this amount gets increased slightly. It becomes 110% of the disputed tax. So the 10% increment is the disadvantage you will have for not filing the declaration on or before 31st March. That is the incremental tax which you will have to pay. But even then, what happens is that there's a relief provision which comes after this. In case this 10% increment of the disputed tax exceeds your aggregate of interest and penalty, then such excess over and above the aggregate of interest and penalty shall be ignored. Now, why is this? Why this is because you are going for dispute settlement only so that you get some relief in the form of waiver of interest or penalty. Now, if you will have to pay a certain quantum of amount which exceeds the total of your disputed tax, interest and penalty, why at all will you opt for the scheme? You will be in a better position not to go for resolution. So in such cases, what the government says is that the excess of this 10% incremental 10% portion of disputed tax over and above that interest and penalty which is getting waived, that amount will be ignored. So ultimately what you will do is you will end up paying the 100% of disputed tax plus aggregate of interest and penalty. The full amount what you owed, you will be ending up paying. Yeah, that is what, but the benefit that you get is that the case gets closed. So the dispute gets resolved. That is the benefit. Now, coming to the second bucket. In these cases, that is the search cases where there is a disputed tax, interest, penalty, etc. If declaration is filed before 31st of March 2020, the quantum of amount to be paid is 125% of the disputed tax. Here also it is only tax, interest and penalty gets waived, but the quantum is 125%, 25% more, because these are search cases. And even here the relief provision applies if this 25% increment exceeds the total of your interest and penalty, then such excess of this 25% of disputed tax over and above the aggregate of interest and penalty should be ignored, which means that you will be paying 100% disputed tax plus interest plus penalty. The full amount what you owe, you will pay. Same way, if the declaration is made after 31st of March, 135% of disputed tax will have to be paid. That is 10% increment. This 10% is the disadvantage which you will be incurring if you make the declaration after 31st of March. Same relief provision applies here also. Now let's come to the third bucket. In this third bucket, these are cases which only have pending interest or penalty or fees, where the tax dispute has been paid. The tax component has been paid, only the interest or penalty or fees component is still pending and being disputed. In these cases, government says, if you make the declaration before 31st of March 2020, pay only 25% of this disputed interest, penalty, fees, etc. and the case will be resolved. In case you make the declaration after 31st of March, there is an increment of 5%. That is, this amount gets increased to the extent of 5% and you will have to pay 30% of the disputed interest, penalty, fees, etc. Aggregate of interest, penalty and fee. On that you will have to pay 30%, not 25%. So that is the 5% increment. These are the quantums of amounts payable. Now, further to this, there are provisions which say that where an appeal or writ petition or any special leave petition has been filed by the department, by the income tax authority before the appellate forum in respect of these cases, not the applicant, not the taxpayer, but the department. In such cases, the amount payable shall be 50% of the stated amounts. That will be the amount payable. And in those cases where the appellant or the taxpayer has already got an order to his or her favor in any of the appellate forums or court, then in those cases where the further appeal has been filed by, further appeal or further writ has been filed by the income tax department, in those cases also where a favorable order has already been given in a lower forum, the taxpayer, in order to settle the dispute, will only have to pay 50% of the amount, total amount, which is to be computed according to this table. So compute the amount as per these provisions, and then 50% of that is the amount which is ultimately payable. That is what this provision says. So this is on the total amount that is payable for settlement of the dispute. Now we have come to the final part of our video. We'll be looking at two more aspects of the scheme. One is immunity under the scheme, and second is possibility of refund if any. Now, immunity under the scheme. Immunity under the scheme is discussed under provisions of sections 6 and 8 of Direct Tax Vivad Se Vishwas Act 2020. Before we get into that, we will also be looking at the provision of section 5 subsection 3. So what does section 5 subsection 3 of Direct Tax Vivad Se Vishwas Act say? It says that for all those matters for which a taxpayer has made a declaration under this act and the designated authority had determined an amount payable, the amount had been duly paid and an order has been passed by the designated authority, all those matters shall be considered as closed. That is, those matters have reached their conclusion, their finality, and they cannot be reopened under any provisions of Income Tax Act or any other law for the time being in force, or any agreement made by India with any other country or any other territory for that matter. So all those matters are closed and they cannot be reopened again. For clarification, the section also goes on to say that by closing a tax dispute under this act, by going in for settlement either by the income tax authority or by the taxpayer, this does not amount to a settlement on the tax position. That is, neither party has agreed onto the tax position of the other party. That cannot be construed. It only means that they have opted for a tax settlement. That's it. They have not agreed with the counterparty's tax position. That is being clarified by section 5 subsection 3. Now going on to provisions of section 6. What does section 6 say? Section 6 says that where the amount payable has been determined by the designated authority and has been duly paid by the declarant or taxpayer, the designated authority cannot initiate any proceedings for the offence connected therewith, or he cannot levy any penalty or charge any interest in respect of the arrear for which the settlement has been opted under the scheme. So those matters are closed. The same as section 5 subsection 3, those matters are closed and no new proceeding or no new levy of penalty or interest can be done for those tax disputes which have been closed under this act. Section 8. Section 8 is the converse of this. What it says is that other than the benefit or concession or immunity granted under these two sections, that is 5 subsection 3 and section 6, no other concession, benefit or immunity shall be construed as granted to the taxpayer for any other matter which is not covered under this act. So what it means is that other than for those disputes which are settled by opting this scheme, all the other matters relating to the taxpayer, no other benefit shall be construed as having been conferred by this act. That is what it says. So those matters are still open and they can be adjudicated, proceedings can be initiated, and they are subject to all the other provisions of Income Tax Act. Now moving on to the other aspect, possibility of refund. This is covered under provisions of section 7. So what this section says is that if any amount has been determined as payable under this act for settlement of any tax dispute, and that amount has been paid by any taxpayer, that amount shall in no way be refundable to the taxpayer. That is, once you decide to go in for dispute settlement and pay the amount what has been determined by the designated authority, that amount cannot be refunded back to you. However, there is also an explanation which is given below, which says that if before filing the declaration under this act, you have already paid any amount towards the tax dispute, and that amount exceeds the amount which has been determined under this act by the designated authority, that excess what you have paid over and above the amount which is determined by the designated authority shall be refunded to you. So the government says it only wants the amount whatever is duly payable under the provisions of this act, which is determined by the designated authority, and whatever is paid has already been paid by the taxpayer over and above that amount can be duly refunded back to the taxpayer. But this particular refund shall not attract any interest under section 244. It is paid only to the amount of excess tax which has already been paid by the taxpayer. Excess amount what has been paid, no interest shall be paid for having this amount with the government for this period of time. That's it. Hope this video was informative. I've also provided the link for the PAR Act and the rules which have been notified by CBDT in the description below. So thank you for watching the video. Have a nice day.